Welcome once again to Lehto's Law. Here's Steve Lehto.
I did the video recently about the cars that were impounded in Flint because the allegation is the drivers were doing donuts in a private parking lot. And the people who owned the parking lot actually called the police and said these people damaged our parking lot. And the allegation is that there's quite a bit of damage done to the parking lot by those people. And I didn't get into that in the video, but I talked about how the police identified the vehicles, impounded the cars, and have announced they're going to auction the cars off as a result. And I was basing my story on a piece I saw, and in that piece, the writer had said that the fact that these cars were on private property might impact the legality of seizing the cars. And I pointed out that actually there's a lot of laws that address things happening on private property which don't need the owners pressing charges to make them stick. The best examples I gave were reckless driving or drunk driving. And reckless driving, of course, does play into what happened in this case. The allegation is these vehicles being operated recklessly by the drivers doing donuts on private property and causing damage to the private property. Now, in case you're curious, if you read the news reports, the owner of the property did complain. However, I had a lot of people ask me and say, Steve, just on a hypothetical intellectual exercise level, what right do they have to seize the cars and auction them off and keep the money? Because wouldn't that be an excessive fine? Especially if reckless driving is the underlying charge, because reckless driving says there can be a fine up to a certain amount of money and so many days in jail, and these cars are worth more than that certain amount of money. Well, a couple of points I need to make, and one of them is that this happened in Flint, Michigan. That is important because, and I did a video about this a few years ago, but I realize now that I always forget. I often think that I'm having a conversation with you. Not you, you. I'm having a conversation with you. And the conversation that you and I are having is all the videos I'm making over the years and all the comments I get back and the videos I continue to make. It's a conversation between us. And I often forget that not everyone has seen every video I've ever made. And likewise, some people probably haven't been watching me all that long in the sense that I think the video is probably 4 or 5 years ago. But there was a time when the city of Flint started cracking down on street racing, drag racing, stunting, showboating, whatever you want to call it, where people are doing donuts and drifting and racing, and they declared it like a public nuisance. And that's the important thing here, because the allegation is that the people who were driving the vehicles, their cars were seized. I believe they've been charged with reckless driving, and they've been charged under a Flint City Ordinance that goes along with reckless driving. And this is important because under the reckless driving statute by itself, the vehicles would not be subject to forfeiture. They wouldn't be, because the statute says a fine and possible jail time, right? So I went and dug it up. It took some effort because it's a Flint City Ordinance as opposed to just a Michigan state law and the blue books behind me. But you should be aware that there are laws at several different levels wherever you might be in America. So there are federal laws, there are state laws, there are often county ordinances, and then there often are municipal ordinances for the city, the village, the township, wherever else is that you more specifically designated as your place of living. So if you lived in Flint, you'd be subject to the laws of Flint, the laws of Genesee County, the laws of the state of Michigan, and the laws of the United States of America. And what we're talking about here is an ordinance number. It comes from chapter 30, not chapter 28. So I know many of you are going, Steve, chapter 28 is where the motor vehicle stuff is. Yes, it is. Chapter 30 is where the nuisances are. Chapter 30 of the Flint Municipal Code. Nuisances. And they added a section under nuisances entitled reckless driving. So it is hereby ordained by the people of the city of Flint. Ordained. An ordinance to amend the Flint City Code of Ordinances by amending Chapter 30, nuisances, by adding Section 30-40, reckless driving, which reads, A, any motor vehicle used to engage in reckless driving in the city of Flint is hereby declared a nuisance. All such nuisances are subject to enjoyment and abatement as provided under state and local law. Any person or his agent or employee who owns, leases, or operates a motor vehicle in violation of this section is guilty of a nuisance. And if you read the section itself on nuisances, it says if there's a nuisance within the city limits, the city's got the right to come in and abate the nuisance. So you've got a house that fell down in a windstorm and has just been sitting there and you kind of abandoned it, and now it's like attracting all kinds of bad attention. The city might come by one day with a bulldozer and clear that lot and charge you for it. They're going to abate the nuisance. So the city attorney, and this is section B, city attorney may maintain an action for nuisance abatement, equitable relief in the name of the city of Flint in Genesee County Circuit Court, and may settle any such action for, at minimum, the payment of an administrative fine of no less than $900 and all accrued towing and storage charges. So they can do that. As set forth in this section, reckless driving means conduct violates MCL 257-626, which is the statute I read to you yesterday. And it says, or otherwise operating a vehicle with willful or wanton disregard for the safety of persons or property, so the damage to the property would qualify as reckless driving, including but not limited to the use of stunt driving techniques, such as figure eights, sliding, drifting, and donuts. And interestingly, I looked and I couldn't find a definition of donuts. So they apparently assume that everyone knows what a donut is. Now, my audience knows what donuts are in the automotive sense. But the interesting thing here is that reckless driving, this section under the nuisances section, simply says that the city attorney can maintain an action. And in essence, if the vehicles were seized because they're subject to abatement, that the city could actually say, well, you can have your car back, but you got to pay at least $900 plus accrued towing and storage charges. But I assure you that elsewhere in the nuisance section simply is the language that says that the city has the right to abate a nuisance as they see fit. And abatement often means the seizure and destruction or seizure and removal of the offending nuisance. And so they're saying that these vehicles in the hands of these people have become nuisances. Obviously, if you owned that vehicle and did nothing wrong with it but drove it within the law, the car is not a nuisance. They're saying that the car in the hands of these people doing this damage have become a nuisance, and they've got the right to abate that nuisance. And so they seize the car, and they say at a minimum, you can get it back by paying all that money, but they say we've got the right to abate the nuisance, which means that we have the right to take the vehicles out and dispose of them. Now, I know some people are going to say, but Steve, I understand what you're saying. I still disagree with it. You are free to disagree with it. And this law, this ordinance was passed recently. And by recently, I mean summer of 2022. So this is a relatively recent law in the grand scheme of things. I don't know if anybody has challenged this on any constitutional grounds or other, because obviously, if they take your vehicle out and they sell it and they make money off it, the vehicle had value, why wouldn't the money go to the owner of the vehicle? And they're going to say, well, no, the vehicle actually was a nuisance, and we abated it in a very efficient way that created money for us. It'd be kind of like if that house that fell down earlier I described to you, if somebody scraped up that residue and took it to a dump, and the dump said, yeah, we'll give you $1,000 for it because there's useful stuff in there. Copper pipes, brick, I don't know, I'm making stuff up here. But my point is, who would get to keep that money? And some people are going to say, well, Steve, it seems to me we've talked before about excessive fines in the Constitution and the Bill of Rights, and a fine cannot be excessive. So if the person gets fined $500 for being a reckless driver and $900 for being a nuisance, then taking their car and selling it, the creation of that money, if they keep it instead of returning it to the owner of the car, that would seem a lot like an excessive fine. And I see that argument. I do. But the city has done this in a way that I think will get them a lot further than if they'd simply said, by the way, reckless driving in our city, you owe us your car. They're saying, no, we've declared this a nuisance and a matter of public health and safety. And I can tell you that these ordinances, because there's a couple of them, were inspired by some massive situations involving street racing and showboating and street takeovers and those kinds of events. And the city council felt they were compelled to do something about it. And so this is what they've done. And like I said, it's a Flint city ordinance, but it's not an ordinance within the driving section. It's an ordinance within the nuisance section. And they're saying this kind of driving creates a public nuisance. And so if you look up the story, simply type in Flint auction and donuts, and you'll find these stories. There's a ton of them. And MLive, which is a local news source in Michigan, has quite a bit of coverage on this. And dig through the stories, because some of the stories are short, some of them have more detail. But one story in particular has an interview with the owner of the lot where this took place. And he says that his lot was damaged because apparently it was recently resurfaced. And the resurfacing cost a lot of money. And somebody went in shortly after the resurfacing, and he says, in doing their donuts out there, damaged the lot. And he puts a dollar value on it that's quite high. And so, believe it or not, in the big picture, high altitude overview of this thing, if the damage that he describes was calculable the way he describes it, and he went after the drivers, there's a good chance he could make a claim for more than the value of those cars. So if all they lost was the cars, on one hand, it might be that they got off cheap. But I'm simply pointing these things out. As a lawyer, you have to understand that not everything I point out is what I think the answer is, nor is it what I think is the correct thing. I'm simply telling you what the law says and what the possible outcomes are, okay? So I'm not saying that these guys who were doing this allegedly need to be fined hundreds of thousands of dollars. I'm simply saying that the owner of the lot could make that argument if that kind of damage was done to his lot. So this is just food for thought. But the important thing here is that I believe that the drivers of the vehicles were cited for reckless driving, and because they were reckless driving while stunt driving, such as figure eights, sliding, drifting, and donuts, then they are also a public nuisance. Two different things. One's a driving violation, and one is a city ordinance within the city of Flint. So there you go. That's the answer to the question. And like I said, I did a video about the situation in Flint and the street shutdowns and the drag racing years ago, but I realized that not all of you probably saw that video. So there you go. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Never trust a computer you can't throw out the window.